Charles Fair has been practicing law for over 30 years and founded Fair Legal because he's passionate about helping others, ensuring that their rights are protected and that they are treated fairly. Fair Legal deals with criminal, family, and civil litigation matters. Charles is generously volunteering his time with CCMF Alberta, that's the Canadian Centre for Men and Families Alberta, to deliver monthly webinars on topics of common concern to the population that we aim to serve. In other words, men struggling due to intimate relationship breakdown and turmoil. My name is Vanessa Farkas Brahmakshatriya. I volunteer with CCMF Alberta, where we are committed to meeting men where they're at so they can feel heard and validated and have conversations that matter to them. We help equip men to manage stressful situations, rebuild their lives after relationships fail, and stay connected with children. We recognize that providing mental health support for men leads to optimal parenting outcomes, a reduction in family violence, and lower rates of suicide. This is an educational offering. It is not legal advice. If you have questions for Charles, note the Q&A button at the bottom of your screen with a little speech bubble and a question mark. Please use that and I will read your answers out loud as appropriate. But please do keep your questions related to the topic of this webinar. And again, make sure that you are not construing what Charles is sharing as legal advice. Last of all, if you're looking for additional supports for your mental health as you navigate your legal challenges, there is a page on our website that outlines all of the programs we offer, including peer support and educational offerings, and that will be available in the chat. So without further ado, over to you, Charles.
Great. Thank you, Vanessa. I'm having some issues sharing my screen, so if I could have that enabled, that would be great. The link to that programs page for the CCMF is in the chat for anybody who wants to go check that out. I am very pleased to be able to assist CCMF on because I think you guys do a great service, and it's really good to see clients or men getting that kind of support in the community.
Charles, can you check if you have access now?
I do. Just a moment here. I'm going to and here we go. I think this will be just a second here. How's that?
Perfect.
Yeah, we're good. All right, super, great. So tonight we're going to talk about disclosure, how to handle disclosure in in family law cases. And this is actually a continuation somewhat of a webinar that I did last November. And it's posted up on our YouTube channel. We might be able to figure out how to give you a link to that. But if you go to YouTube and look up Fair Legal financial disclosure, you'll see it right there. And that covers some of the basics. So tonight we're going to do a little bit in depth on some other issues as well. But I want to talk about three things. One is facing your fears. Second, how to prepare. And those are kind of following through from what I did last November. And then the third one is really the focus of tonight is on business disclosure. What do you do when you have self-employment income or business income? And there's some additional issues there that are of particular importance in family law that are different than the normal disclosure obligations. So to start off with, let's talk about fear of financial disclosure. And I've talked about this before because it seems like when my clients come in to see me, or you go any lawyer for that matter, you're going to see primarily about a relationship breakdown. You're going to see about parenting your kids. You've got all sorts of issues about that. And it often seems like the lawyer fairly quickly on starts to talk about financial disclosure, and you're going, what? I thought I was hiring a lawyer, not an accountant. Why is this lawyer talking about sounding like an accountant? What are they going to do? Do my taxes for me? No. So the more I think about it, the more I think that the problems we have is based partly on that, but it's possibly based on fear, and I'm going to call that the uh, fear of losing everything, and I'm going to call that folly or folly, because it really is folly. And anyway, fear of losing everything is, I think, what is probably underlying a lot of the resistance that we get to getting financial disclosure. And I got to just say, if that's what you are afraid of, then I want you to be the disclosure isn't what is going to take everything away from you. It's probably something else. So what should you be afraid of? Well, first off, the harder the disclosure process is, the higher the legal fees. And it's just a fact of life. If your lawyer has trouble getting the financial disclosure from you, your legal fees are going to be higher. If it's going to, if the other side is having to pry the legal fee, the disclosure out of you, you're going to be facing additional costs down the road. If the other side is not disclosing, the your lawyer is going to be charging you higher legal fees to try to get that disclosure from the other side. Now, there are some ways that we can deal with that. We're going to probably deal with that in a future episode, which is what do we do when we need to get disclosure from somebody who isn't going to give it? And that's might be of some interest to this audience. One of the other things that comes as a result of not providing disclosure is things get delayed. Everything gets slows down because the financial context or the financial situation of the parties really is an important part of the life of children, of the relationship breakdown. And that stuff needs to be needs to be sorted out. Ultimately, the court is trying to reach a decision which is fair for everybody, and or the lawyers are trying to reach a settlement that is fair for everybody. And if we're not getting the disclosure in a timely manner, then there is delay. There can even be delay when you go and say, well, let's do this fast. Let's go get a mediation. And you say, well, let's skip all the disclosure. And then you do the mediation. You come up with an agreement. And the mediator says at the end of the mediation, okay, guys, you got to go out and get independent legal advice. What does the lawyer say? Well, thank you for coming to see me. Before I can give you advice on this settlement, we're going to need to see some financial disclosure from both parties. And all of a sudden, you run the risk of derailing all the hard work you did in the mediation. So it can cause delay in a number of ways. If there's problems in getting financial disclosure, there can be court orders made against you. And, you get a series of court orders on financial disclosure, and it makes it look like you are not being a good player in the system. And that can start to have spillover effect on other issues, unless you've got some good reason as to why you don't have financial disclosure. The court has some tools for dealing with parties that aren't providing disclosure, and they can make adverse inferences, the most common of which would be to say, well, if this person's not disclosing their income, they must have a very high income. And so we're going to infer or impute income to them that says that they're making lots of money. Maybe they're not making lots of money. Other things that they can do is strike your pleadings or make orders not allowing you to defend against whatever it is. So there's lots of different orders that we can get. So, but that's not the focus of tonight. Other things that can happen is they can start to drag third parties like accountants and whatnot into the court proceedings and compelling them to produce documents. And then last but not least, there is costs and penalties involved in if you are resisting financial disclosure. And really, you know, the whole point of financial disclosure is, as I said, you want to try to get, or the courts are trying to get, a fair and reasonable resolution for this case, and that really fundamentally is based on what the reality of the financial situation is between the parties. Now, some tips here. Start early is the first one. You know, and there's lots of tips here, but I'm just gonna give you a few. Start early. Earlier you can get it over with, the better. Second one, perfection is the enemy of good. You just got to get what you have, get it to your lawyer, and then if it needs to be better, the lawyer can advise you on that. Organize if you can, but send what you've got anyways. You know, you might be worried, but oh, this has got to be perfect before I send it in. Just send what you get, what you have, send it in anyways. Ask for, and then the last one is ask for help. The basic disclosure stuff, I want to say you can go take a look at that November 2023 webinar, and I go through some of well, all of the key disclosure items. Typically in Alberta, there's items 1 through 16, and it's just a simple checklist process that you go through, and you know, you just have to go through it. So tonight we're going to talk about though the third topic, which is business disclosure. And really, there's 3 parts to this that are important. And so let me just say first off, when I talk about business disclosure, what I'm talking about is self-employment income. And this can arise, you know, either, you know, you've been a long time self-employed businessman or businesswoman, you are you're running your business, and then you're having a relationship breakdown, and you've got a business, just a business as part of your asset picture. But here's another way that business income is important. You may be a tradesman and you are just simply running a business. It's not incorporated, but you're just doing jobs, you're getting paid, you're paying your expenses, paying your bills related to your business, and then you take home what you can. Maybe you've incorporated your business, and there's some issues that arise from an incorporated business, some tax advantages and things like that. And if you need to be setting that up properly if you're going to incorporate your business. So we're going to talk about 3 aspects of the business. So first off is the business financial statements. The financial statements consist of 2 things. One is your financial statement, your profit and loss statement, which is what was your business income, and then the expenses that you had, and then your profit or loss if your expenses were greater than your income. So that's the first part of your financial statement is that profit and loss statement or income statement. Second part of the business financial statement is your balance sheet, and that shows what your assets are and what your debts are. So how much the company has in the bank, what accounts are owing to the company, what equipment the company owns, what other investments the business has, and then what does the business owe in terms of its suppliers and things like that. So those are that's the basic financial statements that are required for any business. And they're required when you do your taxes, and they are also required when you do your disclosure in a family law situation. So those financial statements are important. It's important to keep them up to date. If you don't have an accountant, you're probably going to need to get an accountant when it comes to a family law matter. So that's the basic disclosure. Now, I'm going to go back to the business deductions and that are shown on the profit and loss. And here's something that may be a little surprising to people. The court says, look, if you've got, say you're making $200,000 in business income, and you've got expenses of $150,000, so you take home $50,000, and you say, well, that's my taxable income. That's what it should be for child support. That's what it should be for spousal support. But the court says, no. You need to justify those or explain that $150,000 of deductions that you've made from your business. You say, well, why do I need to justify it? After all, CRA or Canada Revenue Agency is more than happy to have me pay taxes on $50,000. They don't want to, they say that I can deduct those $150,000 of deductions, and therefore I shouldn't have to, I should be able to deduct them from my business income for the purposes of child support, spousal support. Well, unfortunately, there was a case a number of years ago called Cunningham. And the court in Cunningham said, you know, if you're going to claim that your business expenses as a deduction from your business income, it's up to you to explain what those are and to justify them. Because you can quite well imagine that it's easy if you're the sole shareholder or the sole owner of the business, that lots of business deductions might get past Canada Revenue Agency, but they're not going to get past, but they really have a personal benefit, or they have at least arguably a partial personal benefit. And so that's what the court's concerned about, that you can, sure, you need your car for your business. And so you put your car in your business name, and all of your car expenses you deduct from your business. And the court says, well, wait a second. If you didn't have the business, you wouldn't be able to deduct those car expenses from your income for the purposes of child support. So why should we let you do it when it comes to the business, your business income? Maybe you have a gym membership or something like that, where you're taking clients out to the gym because your gym has got a fancy restaurant attached to it, and it's the club, the business, a great place to entertain businesses, because that's what you're trying to do. You're trying to build your business. You're trying to market your business. You're meeting with people. And the court can say, yeah, okay, well, we get it. We get that those can be deducted for tax purposes. But wait a second, you're getting a benefit from that. You know, if you weren't running this as a business and you wanted to spend your time getting together with your friends at the fancy restaurant, that you wouldn't be able to deduct that from normal income. So no, we got to start adding back some of those things. And it goes to that, things like gym memberships and club memberships and golf club memberships. You can say, well, we go to the golf club and we that's a legitimate business expense. Yeah, but it's not. It's also a personal benefit to you. And the courts are going to say, well, you have to justify it. Now, I personally think you can justify it, and maybe you could say, look, I really hate golf, but I put up with it because that's really critical. That's where my target market is. And so, yeah, it's expensive, but that's what the that's the nature of my business. Well, that may be so, but you've got to prove it and you've got to show the court that, and you can't show the court if you're not disclosing it. And unfortunately, you've got to disclose all your expenses are. And this is where I think people sometimes are reluctant to disclose their business income because maybe they're afraid that the court isn't going to agree with them on some of these expenses. They don't really want the court taking a look at what their expenses are that they're claiming. They don't want their spouse taking a look at the business deductions that they're claiming. Well, you know what? You're better off disclosing and letting your lawyer argue about whether those things are legitimate or not than not disclosing and finding yourself in a whole heap of trouble down the road for the reasons that we were talking about before. So it becomes especially important in the case of the business deductions. So you can get yourself into a situation if you don't disclose, you don't explain what your expenses are, that the court will say, fine. Going back to that example, you're making $200,000 in business income, $150,000 of expenses, you get $50,000 of net income. That's what you pay taxes on. Court says you haven't disclosed. You've disclosed your financial statement, but you haven't explained those deductions. So we're going to say that your income is 200,000. That hurts. Okay. So it's important to get it over with, start early, get your books in order, disclose it, go over all the expenses with your accountant, go over the expenses with your lawyer, make sure that you can explain what they are and why you need them. And then the third big area of this is the retained earnings. So this is going to the balance sheet. We've talked about the two primary financial statements are the profit and loss statement or the income statement. Now we're going to turn our attention to the balance sheet. The balance sheet has, as we said, we talked about this before. There's assets and there's liabilities, and that gives you the net worth of the company. But there's a little magical part of financial statements, the balance sheet rather, that says your assets have to equal the liabilities plus the equity in your business. We talk about that as the net worth, but in that category is what we have something called retained earnings. Well, what are retained earnings? Well, let's go back to that example of the $200,000, but let's change the numbers a little bit. Let's say you're making $500,000 in gross earnings, and you are claiming $200,000 in expenses, and so, but you don't take home whatever that math is, $200,000 in income. You just say, well, I don't need to take that. I'm happy living on $50,000. So instead of giving myself all of that profit of $200,000, I'm just going to keep it in the company. I'm just going to invest it in something, and I don't need to pay. I don't pay income tax on that money because it's still in the company. Still have to pay corporate tax on it because that's part of the profits of the company, but you're leaving those profits in the company. And that's where there's another kind of argument that can happen. Are you leaving those retained earnings in the company because you need to leave them in the company for good, solid business reasons? Or are you leaving those retained earnings in the company so you don't have to report your income, your personal income? And that's the issue that the court is going to be concerned about. And again, it goes back to disclosure. You really have to pay attention to this issue and not be afraid of it, because there's lots of arguments that can be made on the issue of retained earnings. You can say, look, yeah, I had a good year, $500,000, and I've got to put some money away because I can't tell what's going to happen next year, and I want to be able to pay my staff. I want to be able to pay the expenses because if I don't set aside money for a rainy day, then the business is going to fail, and that's not going to be of any use to anybody. So that's a good reason to have retained earnings. But you got to disclose, you got to know what those good reasons are. You got to disclose what the retained earnings are. You got to disclose why you have them, and you've got to justify why they're there and why the court shouldn't be saying, okay, we let you deduct all of those expenses from the $500,000 and you took off $300,000 of expenses, leaving you with $200,000 of net profit. Why are you only reporting $50,000 of income? Why that big gap? And again, if you've got a good reason, the court should accept it. Now, again, going to go back to the disclosure. If you're having trouble with the disclosure, and now you want to say, "Oh, well, you finally got me, and you dragged this information out of me, and I really have a good reason for it," the court's just not going to believe you, right? So it's important to disclose that because then you can talk about why you have the retained earnings. Second part of retained earnings might be quite simply that they aren't the part of your income at all. You've had some good years, you've socked away the money, you've kept it in the company, and you've invested it somewhere, and those retained earnings are now growing, and they're growing on their own. You've invested in some capital growth stock, and those stocks have increased in their capital value, but it's all owned by the company, so now you have your retained earnings or the net worth of the company has increased because the value of those earnings has increased. Well, now again, that's you got to disclose it. And now the argument is, well, all right, is that part of property? Is that growth in the property value of your business something that needs to be shared with your spouse? Or is that something that is, again, is it really part of income? Or is it that would then be part of the child support or spousal support? And there's lots of issues that are related on that. So it's important, again, to talk about the disclosure. Sorry, it's important to do that disclosure so you can have that discussion. So now, I've talked about that in terms of a corporation, and that's the most a clear way to talk about it. But it can also happen if you are not in an incorporated business. If you just have a sole proprietorship, you don't have the issue of retained earnings, but you still are going to have the issue of the deductions from your income. You're still going to have to justify those deductions. So that's that is a kind of the core message, I guess, for tonight is about the business income and those. It's important to disclose that stuff and go over the nitty gritty of the details. Get an accountant involved. Make sure your books are up to date. Get your talk about it with your lawyer. Be prepared to meet and discuss those things. And really, there's no reason to be afraid of it, because if you're afraid of it, it is what it is, and quite frankly, what a lot of guys say is, look, you know what, let's get this over with. It's like ripping a Band-Aid off a wound. Let's get it over with. And this is a big distraction in my life. I can go out and make more money if I just get this over with. And that kind of goes to a weird mindset issue. Do you believe that you're going to lose everything? This is the real thing, that going back to that fear. Are you afraid of losing everything? And so you're trying to hang on to it. But you know what? The reality is that you're not going to lose everything. Unless you start doing dumb things like not disclosing, you're not going to lose everything. And so, and again, if you do it right, if you act with integrity throughout this process and you say, look, I want to do this fairly, and then we're gonna and move forward that way, that is the best way to deal with it. We've been we're at about 7:30 now. I think that's the time when we can move on to questions. Does that sound that I'm on track here, guys?
Yes, you are.
All right, good. All right, so I open it up for questions, and let's take it from there. And again, I just want to remind people that I'm not providing legal advice, and don't get into too much detail in your questions, because that can start to look, other people might be seeing this video, and they might say, "Oh, I know what that case is about." We don't want to get there, and inevitably, there's lots of details in your situation that may affect what the real advice would be. So there's a limit to what the accuracy of legal advice. This is really a public education exercise here. I'm just trying to help give you some ideas and some directions as to what can be helpful. Okay, so.
Okay, thank you, Charles.
All right.
I will read you the questions we have coming in.
Okie dokie.
First one is, I invested $115,000 in my ex-wife's business after we were separated. Just how the dates worked. It was already in motion. Am I entitled to all of that back?
Ooh. Oh, that's an interesting question. And again, there's probably some other facts there that are going to come into play. But when we talk about, there's kind of two issues. What were the terms of the investment? Was this an investment in the shares of the business, or was this an investment like a loan to the business? Because there's two ways of loaning money into a business. I don't need you to answer the question. I'm just kind of on a broad, in trying to be helpful in a general way here for the audience. So when you put money into a company, you're either doing it by way of a loan, or another instrument is a bond or something like that, an instrument that pays out interest, and maybe that might be dependent on certain things going on in the company. The other way of investing in a company is to buy shares, and shares are higher risk because you don't get them out unless there's some kind of dissolution or share purchase, or the business is sold or something like that. So it's a longer term investment. So the first answer to the question is, well, it depends on how you put the money in, and it sounds like this questioner was saying that it was already in motion, and so he should have some idea about what the deal was, because that deal should be honored in one sense. But once you have a breakdown in a marriage or a relationship, and the business is a marital asset, then we've got a different kind of question. Then the question is, well, how do we divvy up that corporation or that business? And a typical way to do that would be to value the business and figure out how to get whatever share of that value belongs to the spouse, how to get that value paid to the spouse. And of course, the fact of a recent investment in the business, presumably you invest in the business, it increases the value of the business in some way, either because it's used to pay down debt, or it's used to purchase assets, or it's used to provide security for an operating line. The idea of investing money in a business is so that the business has higher value, and it's going to make more money. It's going to increase the income of the business. So the business income is increased. Well, that's going to affect things like child support and spousal support. So unfortunately, it's not an easy question to answer. Well, how do I get the money out? Well, maybe you don't want to get the money out. Maybe you're happy that your wife is running the business very, very well. Maybe she's happy to have your money in the business and says, look, let's keep the money in there because we're all going to be better off. Our kids are going to be better off if the money stays in there for a while and we pay it out in some kind of normal fashion or some kind of fashion that works for everybody. So, yeah, unfortunately, there's not a single answer to the question, but it's certainly a good question.
Right. Next one, it's a little long, so bear with me.
Okay. Just remember to take out some of if there's too many details, let's see if we can capture it without the details.
Oh, yes, I agree. This isn't so much personal detail, it's just explanation. So, oh, okay. Oh,
Oh,
sorry about that, everybody.
that's all right. I just got to say, children are what family law is all about. And it's great that you've got a child and, yeah, sometimes our lives have to just, we
I'm well, yeah, she burst in, but yeah, I'm a lucky I'm a lucky person. We got
yeah.
an intact family, so I have no complaints. Okay, so here's the question. We are getting ready for mediation, and I'm working on financial disclosure, including what I consider should be excluded property and what constitutes family property in my mind.
Mhm.
I assume my former spouse will have to do the same. What is the usual process of disclosure? Do mediators make sure to get all this financial information from both sides and disclose it to both of us at the same time ahead of the start of mediation? This should ensure that we iron out potential issues early and have a successful outcome from the mediation process. Can you please share the usual process of setting up for successful mediation?
I got to say that the questioner in this case has really zeroed in on what I think is an important point. I think I touched on it earlier. I think a mediator really should be saying to the parties, you might as well get the disclosure over now. Because you're going to need it later anyways. I said before that ultimately after the mediation is done, the parties have to go out and get independent legal advice, and the lawyers should be asking for disclosure there. So you're better off getting the disclosure done at the beginning. What can happen in mediation is the mediator is really taking their cues or can often take their cues from the parties. And the parties might be more interested in something other than full financial disclosure. And unfortunately, both parties might have an interest in not bothering with disclosure. And that might be for all sorts of reasons. Like, we just want to get this over with. This is a pain in the ass to go and dig out all this stuff. We can't find it. And let's just figure this out. I had a client who came to me and she said, like, you know what, I don't want the financial disclosure. My husband's making $100,000. So I said, well, look, can you get a pay stub from him at least? I know you're in a rush, but ask him for a pay stub. Let's we're gonna have some kind of basis for this. And we right near the end of the year, and she went and got the pay stub, and the pay stub said that his income was 170,000. Well, that's a huge difference. I said to her, "Look, this is a big difference." She said, "Oh, I knew that." I go, what? So that's not cool, right? The disclosure shouldn't be that difficult. And if somebody's not wanting to do the disclosure, I think the mediator should be, having a discussion about, the consequences of not having full disclosure. Sometimes what people say is to say to the mediator, look, we know what our financial situation is, right? We know, we each know it. We've been really open, but how do you really know that? I mean, after all, the marriage is broken down, the relationship's broken down. Are you really sure? And sadly, in the process of marital breakdown, there's this information that comes out that the spouse is, the other spouse wasn't aware of, right? So I think personally, I think the mediator needs to be helping the parties get through the disclosure, and needs to be sure that the parties are agreeing that there is sufficient disclosure and that they don't have any questions about it. And here's one that I had a recent case. And client chose not to represent me, not have me represent her. But in the course of the mediation, husband said, well, this is what my company's worth because this is what's on the balance sheet, or this is what somebody paid me for it, and yeah, they're going to be making some future payments, but this is what the value of the business is. Well, business valuation is a very difficult concept, and I think the mediator might have been maybe a little naive in terms of not recognizing that there can be lots of issues that can go into business valuation, and that there should have been some fairly simple, straightforward disclosure to support that position, but somebody got talked into it, talked into accepting it, and that's problematic. And so if you find yourself in a situation, and this is very good that you're the one getting your disclosure ready, it's reasonable to say, look, I got my disclosure ready. Are we going to do this? And expect that the other side will cooperate. And if they're not cooperating, that's a topic for the mediation to try to figure out, because I think it's a red flag, and it jeopardizes the quality of the outcome of the settlement. Whether it's a mediation or an arbitration or going to court, you start cutting corners on the financial disclosure, reduces the quality of the outcome.
All right, next question. If you get a settlement from a car accident, do you have to disclose this, and will this or profits earned from this amount be used towards spousal or child support?
Okay, so number one rule, disclose, disclose, disclose. Do you have to disclose? Yes, you have to disclose. Second question is a different question. Is it exempt, or will it be taken into account? That's a separate issue. There was a man in Manitoba, I believe it was, or Saskatchewan, a number of years ago, that won the big lottery after or right around the time of separation, and he decided that he was just going to roll the dice, and figured, well, if he didn't disclose and she found out about it, he'd have to pay her half. And what happened was she found out about it, but the court said, no, you didn't disclose that. So no, we're not going to reward that kind of behavior. And you could just imagine, just guess what would be the worst possible outcome in that situation. That's what happened. He had to pay all of it to his wife. That's why disclosure is so important. If you try to hide something, it's not going to work for you. Now, when it comes to personal injury settlements, there's a personal injury settlement has various components to it. One is pain and suffering. That is exempt as far as I know. No, I might be wrong on that, but the pain and suffering component of a financial disclosure is exempt from division. Okay. The loss of income may not be exempt from division. And so again, I think it's important to do the disclosure about, well, what portion of the personal injury award was related to income loss, past income loss, and future income loss, and how much of it was related to compensation for pain and suffering? How much of it was allocated to future cost of care? That sort of thing. So some of those categories are going to be exempt from disclosure, and others of them might not be. So again, now, not every case breaks out the heads of damages that way, or those categories of damages. Sometimes it's just a global settlement. They say, "Ah, we're not going to bother breaking it out." And I think that again, that kind of exposes you to some risk about how how that property or that award gets dealt with. But here's another thing. There's two questions when it comes to personal injury damages. We've talked about the categorization of what the damages award was for, but on the other hand, there's really two components in the terms of family law. One is this an asset to be divided, or is this an asset that generates income? Because if it's an asset that generates income, that income might be something that needs to be taken into account in terms of the overall disclosure, the overall financial arrangement between the parties. So um, if the uh, if the very large asset is invested and it's generating an income that isn't used for care expenses, that sort of thing, then there's an argument that at least some of that income should be taken into account when it comes to support obligations. But it's not. Please don't take that as a an answer to the specifics of your question. There's just lots of moving parts on that. So again, disclose, 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 work out what the details are on that. And there's lots of good arguments on both sides of it as to why it should be exempt, all of it exempt, why should it be kept out of income, why it should be included in income. There's lots of arguments either way. Okay.
All right. How does it work if your former spouse closes a GIC and converts it to a bank draft around the time of disclosure and then proceeds to hide it during disclosure? We have the paperwork and can see when it was closed and removed as a bank draft.
Yeah. Yeah. Well, there's some procedural things that can be done, like a notice to admit facts that can might put some pressure on them. I think that it's just simply um, the the money's been taken and hidden. Well, you just say that it was taken and hidden, and you put it back on the balance sheet for the balance sheet, not the business balance sheet, but the balance sheet between the parties. What's hers, what's his. Um, she's hiding something. Well, you just put it back in, right? And then she has to explain where it went. Now, sometimes that can be a difficult process if you don't have the proof. So there's ways of dealing with that. And again, that's when what we do when we get disclosure from another side or from our parties, we start looking at it with a kind of a magnifying glass. We take a look at it and say, okay, um, we see income, we see money going into a bank account, and we see money being transferred to another bank account. We say, wait a second, we see a bank account number there. Do we have disclosure of that bank account? Right? And we do that with our own client because we don't want to be taken by surprise. We don't want to be the ones caught hiding. But we do it with the other side's disclosure as well to say, okay, we see that there's a disclosure, a payment to another bank account or a transfer another bank account, or we see a payment to an undisclosed credit card. We need to get more financial disclosure. That's kind of very simple kind of auditing stuff that we do at Fair Legal. It can get much more sophisticated than that, especially if you've got a business. You can bring in a forensic auditor to take a look at the business transactions and see whether there's money that's been disappearing. That tends to be a very expensive proposition. Proposition is basically used in it really when there's a lot more money at stake. So
If I had proceeds from the sale of a property during the relationship and had spent a large portion of it on rent, legal fees, etc. after separation, however, before disclosure, and was left with, say, only 20% due to the surmounting costs after, how does that work?
Um, Really, the basic rule in Alberta may seem a little surprising. Property division is as of the date of trial, not as of the date of separation. That means that all sorts of things that happen after the separation can still be taken into account. The presumption of property division in Alberta is that the parties are sharing equally the additions to income, or sorry, the increase in their assets during the course of the relationship as of the time of trial. So from the date of the relationship started all the way up to trial, it's presumed to be equal. However, after the separation, there may be other considerations that come into play that say, like, while it's fair to say that during the course of the relationship, the assets should be shared equally, after separation, it may not be quite as clear. Again, disclosure is important here, and those expenses after separation may still be regarded as legitimate marital expenses that would be taken into account. There's another issue that can arise with the sale of assets and then what happens to them, and that is the issue of tracing, and that's probably a whole other comment here, but I just want to say this isn't quite what the questioner was asking about. But if, say, both parties have a house or a substantial asset, and one of the parties sells the house, takes the money, and buys another asset, and then they take that asset and they sell it and they buy another asset with that. They came into the relationship with the house and now they've sold it, bought another asset, sold that one, bought another asset, and now they have this third asset that didn't exist at the time of when they started the relationship, but did exist. But the funds can be traced from asset to asset to asset, and it was always owned by the same spouse. That's a tracing rule. Well, that last asset is exempt from division because the first one was exempt from division because it came into the marriage. Same thing with an inheritance. An inheritance is received by one spouse, and they put that money into a separate account or a separate set of investments or whatever they do with it, but they always keep it separate. That that asset is exempt because it was an inheritance just to the one spouse. The other spouse brings a house into the relationship, or they receive an inheritance, they sell the house or they cash out the inheritance, and they start using it to pay everyday living expenses for the couple or for themselves, and they spend it. Unfortunately, they lose the exemption because it's no longer there's no longer an asset that it can be traced into. And when you get a situation where one party has done that and the other party has kept themselves separate, yeah, it really hurts. But unfortunately, that's what the reality is. Unless you can come up with some argument to say, look, this is fundamentally unfair, and I can think of some arguments why it might not be fair to disclose, to approach the case in that fashion.
That dovetails nicely into our last question of the evening.
Okay.
My former spouse's father paid the down payment of $200,000 to our rental property. He signed a gift letter from the bank to both our names. She now claims, after our separation, that the $200,000 is an excluded property. What is the law?
That one is, she's going to find it very hard to enforce that, not just because of the gift letter, which is, you can't take a position with respect to the bank and then take a different position with respect to the matrimonial property division. Okay, so that's one problem. But the other problem is it was a gift to both of the parties, and that's regarded as a gift to both of them. So now how do you divide up a gift to both parties? Well, half to one and half to the other. And so now there might be some other issues. So, be careful about just running off and saying, yeah, this is what a lawyer says, but that's the basic rule. Unfortunately, it happens quite often that the parents get involved and they then claim that there was a debt or whatever, and that gets litigated, and it's a great delay. And at the end of the day, it's probably not a debt, a legitimate debt, and so it's not regarded as that. And it is possible. Early on in my career, I was representing a young lady that her parents did lend the couple money, and what they did is they put a mortgage on the house, or second mortgage, or whatever it is. They documented it, and that was all above board. And what was really interesting to me in that case is that demonstrated, I think, a very healthy approach to finances between the parent and the child. And it didn't come as a surprise to me that couple were able to sort out the differences and ultimately reconcile, because at least the wife had been trained well by her parents to recognize that money is something that should be dealt with, not in fuzzy, manipulative, this is a gift today, but it's a loan tomorrow, and that vice versa, and all of that. They were just straight up about it, and I think that was a healthy way to deal with it. So there, a little anecdote from a long time ago. But
Well, our timing is perfect. We have answered all the questions that came up, and it's 7:59.
all right.
So thank you very much, Charles, as always. This was a particularly, I think this was a particularly content-rich offering, in part due to the quality of the questions we received. So thank you to everyone who submitted questions. They were great.
It was very great. And I just want to say, if somebody does want to get some further advice, then contact CCMF. You do that, you get 30 minutes with me for free. If you contact my office directly, then you have to pay. So there's a benefit for working with CCMF on that.
Yes, and please come through our website in any case, because we have other programs that